to start. Welcome everyone to the last guest seminar on the term, not counting the Nigel Walker lecture. I'm very, very delighted today to welcome Arushi Garg, who is our guest speaker. Arushi was appointed assistant professor here in 2022. Before that, she held a lectureship at the University of Sheffield and a series of teaching positions at the University of Oxford, where she did her DPhil, MPhil and BTL as a Rhodes Scholar and a Mann Senior Scholar. Arushi completed her undergraduate degree in law at Nalsa University in India, graduating with several gold medals and a mention in the Vice-Chancellor's merit list. One of Arushi's journal articles on deceptive sex cases won a research award from the Asian Law and Society Association. She's currently completing a manuscript based on her ethnographic and legal record work in relation to rape and criminal justice to be published as part of OUP's Clarendon series, Clarendon Studies in Criminology series. I'm one of the editors of that series, so I'm very delighted to got her. And tonight she's going to talk to us about that work under the title Legal Pluralism in the Post-Colony, Understanding Women's Experiences of Rape Trials in Delhi. We're very much looking forward to hearing about your work on women's legal worlds and conceptions of justice. Over to you, Arushi.
Thank you, Alison. And thank you to all of you for attending my seminar today. So as the title of the presentation suggests, today I'm going to be talking to you about women's experiences in rape trial courts in Delhi. And the main thing that I'm going to focus on is this rather wide gulf that tends to exist between criminal law mythology on the one hand and the actual practice of the criminal law on the other hand. And the fact that there is this gap between criminal law mythology and reality, I'm sure it doesn't come as a massive shock to anyone sitting in this room. But it was a little bit of a surprise to me when I first started conducting research on this topic about a decade ago. The extent to which criminal justice did not seem central to the lives of rape complainants. Even those complainants who had demonstrated a great amount of energy and vigor and resilience in getting the police to record and investigate the incident in the first place, and in basically ensuring that the case file at least reached before the trial court. A significant proportion of even these victims tended not to support the prosecution through their testimony, despite having initially filed the rape complaint. This did intuitively make sense to me. And so this paper is really one attempt at trying to understand this phenomenon better. So to me, if we are to make sense of women's experiences and uses of the law, or women's legal worlds, as Emrina Manji calls them, it's important for us to actually look outside the criminal law system and to ask this question of what is important to women. So this is something I hope to do over the course of the next 50 minutes or so. So for, once I can get the slides to move. Okay, so for all the structure nerds out there, I'll start by introducing the broader project of which this paper is a small part. I'll then walk you through some theoretical frameworks that have helped me make sense of the primary data. And I'll then analyze two categories of rape cases in which I suggest that the outcome is best understood by decentering the criminal law system and focusing instead on women's experiences and priorities, even when these priorities conflict with what the criminal justice system understands or assumes them to be. And finally, I'll end with concluding reflections on which interests are then served or not served by way of the criminal justice system. So the broader project from which this research is drawn is the monograph project that Alison mentioned, which seeks to understand rape adjudication in India more broadly. And my interest in this topic really emerged from the gaps that exist when it comes to conviction rates in rape cases, which tend to be much lower than conviction rates in other types of cases, right? And we see this in India, we see this in several legal systems across the world, But just to give you a sense of the numbers from India, so if we look at the latest figures from the National Crime Records Bureau, then the conviction rate in rape cases is about 27%, whereas the overall conviction rate for offenses generally is about 66%, right? So I don't want to glamorize the idea of having high conviction rates. And I'm also really conscious that focusing on the legal category of rape is itself quite a limiting thing to do, right? So under Indian law, for example, rape can only be committed by a cisgender man against a cisgender woman. And, I could reflect on several such limitations, but just to say that the differences in conviction rates are so stark and they're so consistent that to me, it indicates that there is something distinctive that is happening in this category of cases. And I was curious to learn, well, what is this distinctive thing? So against this background, I then undertook fieldwork in Indian trial courts over a period of 6 months in Delhi in 2016. And during the course of this period, I collected data from mainly 3 sources. So I analyzed all rape trial court judgments from Delhi over a period of 12 months. I also conducted semi-structured qualitative interviews with victim support persons, with lawyers of various tribes, and also with judges. And finally, I carried out court observation in 6 different courtrooms in Delhi. So a thematic analysis of this data then revealed several factors that are associated with acquittal and conviction. But by far, the most prominent reason that was cited as a ground for acquittal was the fact that the victim withdrew her support for the prosecution. And this was the stated reason for acquittal in about 151 of the 254 judgments that I analyzed. So really, it was begging the question, like, what is happening here? But before I begin to answer that question, I'm going to build up more suspense by walking you through my theoretical frameworks. So the main theoretical backbone of the project is postcolonial feminism. Legal feminism in general seeks to identify, analyze, and also challenge the gender-based inequalities in the scope and operation of criminal laws. But postcolonial feminism is then more specifically interested in how colonialism has shaped gender relations and specific manifestations of patriarchy across much of the modern world. So this includes post-colonial countries, settler colonial countries, and also metropolitan settings. A really key feature of this analysis is how traditional ideas of womanhood within certain very prominent strands of the anti-colonial nationalist struggle became enmeshed with questions of national honor. And I'm going to talk about this process of the melding together of womanhood with nationhood, with tradition in slightly more detail, because it does continue to exert quite a strong influence in India today. So Partha Chatterjee and other historians have written about how under British colonialism, the so-called native population exercised quite limited control over what happened in the political or the public sphere. And so as a reaction to this led to the intensification of networks of control that were exercised in the private sphere. And this then had a heavy impact on gender relations more generally, but also quite specifically on conjugal or marital relations. So in the nationalist imagination, Indian womanhood became symbolic of something that was pre-colonial, something that was kind of untouched and uncorrupted by colonial contamination. And this type of elevated Indian womanhood was by definition most readily available to the elite women of the nationalist movement, who then tended to be relatively well-off, upper caste Hindu women. And once womanhood became symbolic of national honor in this way, of course, it became especially important to protect Indian women from corruption through westernization. And women also then had to be protected from their own sexual agency, because now any stain on women's respectability, even if it was self-inflicted, it became a taint on the communal and national honor. And what better way could you have of protecting women's respectability than the heterosexual marriage? So the centrality of the institution of marriage in nationalist thought is really quite key to grasp. And given that what was really at stake was the respectability of elite Hindu women, the version of marriage that came to be emphasized in revivalist nationalist circles was basically marriage within caste and religion, right? Because it's like through this type of marriage that you could protect the so-called caste and religious purity of these women. So what you had then was a system of controlling women's sexual autonomy, but with a view to further reproducing caste and religious stratification. So under colonialism, pre-colonial entanglements of womanhood with gender, with caste, with religion, became kind of merged together with questions of national honor in a way which has by far outlasted the British Empire. So it's not that the story of marriage in post-colonial India has followed a neat or a linear trajectory. So there have been really important challenges that have been made to this institution also. But especially in recent years, with the rise of a far-right hyper-nationalist government, what we see once again is that a very rigid idea of marriage has come to be emphasized, which really entrenches caste-based and religious-based cleavages. And I think a good example of this is the kind of moral panic that we see around so-called love jihad, which is basically where a Muslim man develops a consensual romantic relationship with a Hindu woman. So within far-right ideology, these relationships are then regarded as theft of the woman from the Hindu community with a view to ultimately destroying that community because, of course, within far-right thinking, you would need these women to be bearers of Hindu children. And so this is just an example to show that while post-colonial feminism gives us a fruitful framework for understanding gender relations in colonial, but also in post-colonial India. And it engages not just with the metropole-colony dichotomy, but also with this sort of range of intersecting inequalities which can include race, nationality, gender, and all the other things we've been talking about. So for us, this becomes quite important because, well, for me, it becomes quite important because the decisions that women make in the context of rape prosecutions are heavily influenced by where they are located in this matrix of intersecting inequalities. And so this is a point that I'm going to keep coming back to during the course of my presentation. Critics of post-colonial theory have suggested that it privileges European colonialism over other historical moments, and also that it understates the influence of equally or perhaps even more oppressive systems of power. It also really doesn't help that the language of decolonizing has also now been appropriated by basically an authoritarian state. So you can have this totally bizarre situation where renaming roads or places or islands and giving them Indian names can be regarded as a type of decolonization, even though in public, on trains and on the streets, Muslim men continue to be lynched for possessing the wrong type of meat, right? So how do we understand these contradictions? I think it's worth reminding ourselves that when we use this term coloniality, we are referring to a broader framework for understanding multiple oppressive systems, which are often premised in the economic exploitation of people, who are then also typecast as being culturally or civilizationally backwards. And that's what provides the justification for their, the so-called justification for their exploitation. So in this sense, British colonialism is, of course, an important historical force that shapes what happens in India today. But it does also interact with contemporary developments, such as the rise of far-right politics in India. So while the vocabulary of decolonization might have been co-opted by a far-right government, I would suggest that this is really not the first time in history that a progressive concept has been appropriated or co-opted by a regressive government. We've seen this happen, for example, in the way in which the very idea of feminism is often co-opted and weaponized within various different contexts. So it's not the first time, and I would be shocked if it were the last. Just two more points to make in relation to postcolonial feminism. So one being that because postcolonial feminists understand gender as being mutually constitutive with other systems of inequalities that cast in gender, it is then less vulnerable to generalizations that women are uniformly or homogeneously victimized. And again, for my purposes, this was quite useful because it allowed me to explore not just women's victimization in the context of rape trials, but also the ways in which they might exercise their agency. And again, this kind of victimization and agency tussle is something that I will come back to in later parts of my slides. And finally, it's worth saying that because of the role played by colonial governments in creating, sustaining, and then also entrenching gender-based inequalities, postcolonial feminists tend to be, if not critical, then I would say at least ambiguous about the state's potential to produce some kind of feminist liberation. And so this view of law, I feel it paves the way for engaging with women's legal worlds as they are, rather than, again, as the criminal justice system might imagine them to be. And this then brings me very neatly to the second theoretical foundation for my project, which is the body of scholarship around the concept of legal pluralism. So legal pluralism, as the term might suggest to many of you already, it basically refers to the coexistence of multiple normative orderings in society, of which the system of state laws is only one type of normative ordering. And this exists in a non-hierarchical relationship with other forms of normative ordering. So, okay, lots of people looking at me slightly blankly, which is always a good cue to give an example. So, let's say that I'm an employee of, I am an employee of the university. So we don't need to imagine it quite helpfully. But so my conduct will be regulated then, at one level by laws that are enacted by the state. But in addition to that, there will also be organizational policies in my department or in my university that regulate my conduct. And in addition to these formal sources of social control, there might also be conventions or informal norms that I consider myself bound by. Right? There might be conventions around what it means to be a good academic, what it means to be a good colleague, what it means to be a teacher. And it may be the case that if I act in violation of these norms, nobody is going to initiate formal disciplinary action against me. But I might choose to comply with them anyway because I want to be accepted into the broader community of academics, which I identify with, right? And there might be situations in which actually these informal norms or conventions about what it means to be an academic, they actually outweigh what the system of state laws is expecting of me, right? So this is the basic idea behind legal pluralism, that there are multiple normative orderings, and they might exist in a non-hierarchical relationship with each other. I think legal pluralism in the context of the study is best understood by contrasting it with its converse ideology, which is the ideology of legal centralism. So in a legal centralist framework, the system of state laws, it exists as a single, unified, and hierarchical system of normative ordering. And lots more could be said about this characterization, but again, the point that I want to emphasize is this idea of hierarchy. Right? So in a legal centralist framework, the system of state laws exists as the most important and most dominant type of normative ordering, which trumps every other type of regulation wherever there is a conflict between state laws and non-state community norms, right? So that's the idea behind legal centralism. So legal centralism might suggest that if an incident of rape is inflicted, and when this is a serious crime, so the police will go to the police, the victim will go to the police will investigate the case, the prosecutor will prosecute, the judge will try the case and will convict and then sentence the defendant. But a legal pluralist approach would suggest that if an incident of rape is committed, then the criminal justice system presents only one type of response, right, which may or may not be the response that is chosen by the parties. So if rape is committed by one friend against the other, for example, the victim might confront the offender might apologize, and that might be the end of the matter. If rape is committed by one colleague against another, the victim might go to her line manager and say that I don't want to be put in the same working teams as this person. The line manager might comply with her request informally, and that's the end of the matter, right? She might not want any intervention from the criminal justice system. In a different type of context, let's say the victim discloses the fact that she's been raped to her family. Her family might force the victim and perpetrator to get married to each other. And they might say that, well, this act of marriage has now atoned for the misconduct, and so the matter might end there. Right? So, I mean, all of these examples to show that, whether or not the criminal justice system is relevant and the extent to which it is relevant, it really depends so much on the circumstances, and that we can't assume that a criminal justice system response will take priority. It could be just one of many options on the table. So is legal pluralism a good thing or a bad thing? I mean, there are a range of responses to this question. In the 70s and 80s, if I can borrow from Mitra Sharafi's words, she said that there was an aggressive optimism around legal pluralist scholarship. And in a way, we can see why this was the case, because state laws were associated with imposition, with domination, with the flattening out of cultural differences. State laws were adversarial, they were binary, so they generated winners and losers and sort of created more strife. Legal pluralism, in contrast, was associated with negotiation, with dialogue, and with a greater recognition of cultural differences in a way which could make the outcome more acceptable to the parties involved. So there did seem to be some benefits of existing in legally pluralist societies. But at the same time, I do think that there are some challenges to treating legal pluralism also as normatively desirable. And the main such challenge to me is that community norms can also be highly sexist, casteist, and generally quite repressive. So my intention really isn't to romanticize legal pluralism or to put it on some kind of a normative pedestal. I'm using legal pluralism in a more descriptive rather than a normative sense. So I think it gives us a useful framework for understanding what is actually happening in trial courts. Sometimes the criminal law is it's peripheral, it's not central to how people think about their lives. Sometimes it can be significant and it can be relevant, but it can be just one tool of many that people use to negotiate and to arrive at outcomes that they feel that they can live with. So to use my conceptual tools of postcolonial feminism and legal pluralism within the context of the study, I now want to turn to the 151 judgments I mentioned, where the victim refused to support the prosecution despite having initially filed the rape complaint. So 55 of these were what is conversationally referred to in India as promise to marry cases. Which is what my award-winning article was about. But I want to put these cases to one side for now, because I do think that they raise slightly more particular issues. So I want to park them to one side, and I'll come back to them a little bit later into the presentation. So I want to focus for now on the remaining 96 judgments, where to use the term used in the judgments, the victim turned hostile to the prosecution. Judgments in these cases tended to be quite brief. So they would generally just record the victim's testimony that she did not support the prosecution because her initial complaint was based on some kind of pressure that had been exerted on her, or some way in which she had been misled by the police, by other members of her family, or by third parties to the case, as in by third parties who were not directly involved with the case. But I felt that this cryptic summary of reasons, it often didn't reveal victims' actual motivations, as I gleaned them to be through interviews and through ethnographic observation. A more nuanced understanding of the victim's motivations is available to us by turning our attention to the legal pluralist context, and also by trying to understand women's relative positions of power and powerlessness within the post-colonial society they inhabit. So broadly speaking, the primary data revealed two types of cases. Those in which it seemed that the complainant was compelled or pressured to change her testimony through threats or some kind of intimidation, for example, and those in which the victim seemed to have entered into some kind of voluntary, informal settlement agreements with the defendant, in which she would basically undertake to testify in his support during the trial, in exchange for some other type of extra legal relief or benefit that was offered by him to her outside the space of the trial. So this kind of extra legal relief or benefit, it could be in the form of a monetary sum that he paid her. It could be in the form of a promise of employment. It could be in the form of an undertaking that he would not evict her or that he would stop encroaching on her immovable property. It could be in the form of a promise that he would repay a debt that he owed her. In circumstances where the victim was married to the defendant's family, it could also include an assurance that she would get a hassle-free divorce with good sort of maintenance rights and custody rights over the children. So the exact consideration that was available to the victim was quite a varied and multidimensional thing. And having just given you this twofold classification, I'm going to retract it almost immediately because these cases actually did not exist in watertight compartments, right? So where the victim, so the victim's willingness to enter into a settlement agreement was much enhanced, where she also experienced some type of pressure from the defendant or even from members of her own family who were keen on the settlement or who did not want the stigma associated with the rape case. And to complicate things further, the pressure on the victim, it could be interpersonal or relational in the ways that I've just described, but it could also be institutional or structural. So when I talk about institutional pressures on the victim, I'm referring to the fact that basically the rape trial is a hugely re-traumatizing experience for most victims. And the kind of very high degree of secondary victimization they face can make it seem more sensible in some ways to just settle the dispute informally and quickly, and to actually get something out of the process for yourself, and not just interminable delays and maltreatment from criminal justice officials. When I refer to structural pressure, I'm referring here to say structural oppression in the form of poverty or homelessness or single parent status and other structural factors like that. So then we have a situation where the victim is often choosing to enter into these agreements, but this choice is being made in a highly constrained context where the victim is often choosing the lesser of two evils, which can then allow, entail allowing impunity in the rape case. And so to give you a quick flavor of the sort of things that came up in the interview, this is from an interview with a victim support person, and I specifically asked her about reasons why victims might change their testimony. So she starts by talking about the institutional pressures on the victim's family, right? That sometimes it's very difficult for the family to keep going to the police station or to keep going to the court. But then she talks about interpersonal or relational pressure, and she says, well, at times even the parents or the family might not support the victim. And then towards the end, she starts talking about structural pressures, such as poverty, right? So she says, the victim's financial condition might not be good, and if they can't fulfill their needs, they might get distracted from the case and enter into a settlement agreement. Linked to this last point, in the next slide, also I have a quote from quite an experienced criminal lawyer who talks about victims who are facing oppression by virtue of their religious or class-based identity. And I mean, she starts by talking about communal riots, but later she does say that this is a kind of recognizable scenario in different contexts as well. So she says, speaking about the victim, nobody will care for her, and it is beyond a shadow of doubt. She will be approached, she will be coerced, she will be threatened, she will be made to somehow retract from her original story. Now, she is poor, she cannot dislocate to another place. She is dependent on the male relatives who surround her, who are quite happy being paid off for her silence. At some point, she will just give up and say, okay, never mind, I am not proceeding further. And I mean, I could keep multiplying these quotes, right? But I think this gives a sense of the very significant constraints that limit the victim's freedom to decide which way she wants to testify in the rape case. And in several of these situations, the victim is arriving through some kind of a negotiation at an outcome that better suits her needs than maybe the legal system is able to do. So while the trial might not be serving the victim's needs in a way that's meaningful to her, the threat of conviction can still form part of the background against which the victim is sometimes able to bargain with the defendant to secure the least undesirable option in what is actually already quite a sorry situation. It is worth noting that the withdrawal of the victim's support to the prosecution is routine and is typically not a reflection of the authenticity of the allegation or not. So from the fact that the victim refused to support the prosecution, it won't be correct to infer that the rape case actually never happened. The other point I want to reinforce is that these settlements are extra-legal and informal, right? So legally, there isn't a way to enforce these bargains. Once a trial commences in an Indian trial court, it's really difficult to take it back, right? There's no straightforward legal way to just take the rape case back. We do have systems of plea bargaining or other processes that allow the victim and defendant to settle the case outside court. But these mechanisms are not available in a rape case, probably because of the serious nature of the offending alleged, right? So these agreements or understandings, if you want to call them that, they're entirely extra-legal, entirely unenforceable, and both parties are actually at the mercy of societal or extra-legal norms that dictate that they must comply with the bargain that's been struck. So I want to end, sorry, I intended to remove that stern bullet point, but then I forgot. But when, as the slide suggests, please pay attention to the vignette that I'm going to read out. And I think it's a good way of tying together the threads of the argument that I've been developing over the past few slides. And it gives you kind of behind the scenes view of how these cases actually play out in court. So when the victim witness turned hostile, the judge got angry and asked how many years she should spend in jail for filing a false complaint. The victim witness seemed to panic, and she said that the incident had indeed happened, but she felt too ashamed to relate it in front of the men present in the room. The judge reminded her that they had already ensured that her testimony was recorded without the public present in the courtroom, and the only person she really needed to address was the prosecutor, who was also a woman. So the recording of the testimony proceeded, including the account of rape. But once the matter was adjourned, the victim witness approached the prosecutor privately. She admitted that she did not want to proceed with the case because she had entered into a settlement with the defendant. The judge overheard her and was immediately incensed. He asked if she thought that the criminal justice system was a personal car which she could start and stop at will. He warned her that he was going to make sure that the case was prosecuted to the end because she might have arrived at a decision, but the court's decision remained to be made. The victim witness protested, saying that she needed the settlement money to raise her children, but the judge was adamant, asking why she could not afford to raise her children when she was a working woman. The victim witness responded, saying that she had no stable source of income. She was a daily wage earner, and there was no guarantee of whether she would secure employment on any given day. After the judge left, the victim witness returned to the prosecutor and repeated that she wanted to take the case back. The prosecutor initially gave evasive replies, saying that only the judge could help her. But finally, she told the victim witness to address her queries to the defense counsel. The victim witness added that she was under huge pressure from her landlord to take back the case, but the prosecutor did not react. After the victim witness left, the prosecutor was asked what would happen in the case. She said that there would probably be an acquittal, but none of the background conversations regarding the settlement would form part of the record. So, I mean, the vignette is over, but please keep paying attention. So, for me, these cases raise really interesting questions about the tension between women's victimization and agency, and also the victim's priorities and how they sometimes seem to be in conflict with the state's priorities. We could also ask interesting questions about the relationship between state and community mechanisms for responding to these types of conflicts. Many of these themes also manifest in the second category of cases I want to talk to you about, but in a slightly different way. So the cases I have in mind here are promise to marry cases. And these are cases in which basically the allegation is that the defendant has deceived the victim into having sex with him based on a fraudulent or dishonest promise of marriage. And the prosecutor's argument would usually be that, well, the fraud or deception practiced by the defendant, it vitiates or it cancels out the victim's sexual consent. So of the 254 judgments I analyzed, quite a significant number involved promise to marry cases, right? So 84 were promise to marry cases. And in 55 of these, the acquittal resulted largely from the fact that the victim did not support the prosecutor through her testimony. And of course, all of the factors that we've been talking about in the first part of the presentation, they don't disappear for this category of cases either. But something quite particular that was happening here was that in almost 40% of the promise to marry judgments in my data set, the victim and defendant were also married to each other at the time of the trial. And I found this quite curious. The fact that the defendant was probably agreeing to marry the victim in order to evade a rape conviction is not something that the victim or anyone else tended to record as a part of the formal record. But outside the space of the formal record, it was really quite an open secret, including, one that some victims were willing to admit that the primary motivation in filing the rape complaint was to secure marriage with the defendant rather than to secure a conviction. So this is just an exemplary quote from a support person who says that in promise to marry cases, the victim is very rigid. No, he is the only one I want to marry. In all these cases, the only objective of the girl is to marry the boy. And for me, the reason I think it's similar to the cases I've been describing so far is because once again, we see that what the criminal justice system is able to offer, which is a conviction, is really not what the rape victim is interested in, which is marriage, right? So, I'll say a little bit about this desire for marriage, but I just want to add a fuller context to some of these cases so that we get a better understanding of what really is at stake. So the first thing I want to know is that note is that in many of these cases, the sexual relationship happens within the context of quite a prolonged romantic attachment, right? And it is this romantic relationship which makes the promise of marriage believable in the first case. That intimate relationship is very often characterized by a high degree of abuse, which can include financial, emotional, psychological, physical, sexual violence. So for instance, one promise to marry victim I interviewed, she said that she was a committed Catholic and she had been quite clear from the outset with the defendant that she would only have sex with the man who was ultimately going to be her husband. Her account was that he took vast sums of money from her during the course of their relationship, on the pretext that he needed this money to pay off his ex-wife, to pay her alimony so that he could then be free to marry the victim. So she indicated that there was economic exploitation. She described experiencing physical violence from him. And she also described being forced to undergo multiple abortions, which she experienced as something quite fraught because of her religious beliefs. Ultimately, she narrated that he refused to marry her because he said that she was too dark-skinned for him. Now, none of the domestic abuse that forms part of the courtship tends to get reported to the criminal justice system, for reasons that are actually very similar to the underreporting of domestic violence in abusive marriages. And if anything, there is a heightened anxiety on the victim's part that if she speaks out about the abuse or if she creates a fuss about the abuse, then she loses the chance of getting the relationship validated through the respectability of the institution of marriage. So it is only when that promise of marriage turns out to be a fraudulent one that she will turn to the criminal justice system. And once the option of marriage becomes available again, then the conviction stops being a priority. And in those circumstances, the victim might choose not to testify in support of the prosecution. So why is the complainant seeking reconciliation and marriage over retribution? Again, I think the domestic violence literature is quite helpful here. So it talks about intrapersonal, relational, and social reasons for why women in abusive relationships might still want reconciliation. So the intrapersonal reasons can, of course, be quite varied, but I think the relational reasons are, of course, quite relevant because, as I said, the sexual relationship is within the context of a prolonged romantic attachment with the defendant. But I think what's interesting for us also is the social reasons, because in the first part of the presentation, we were talking about the various historical and contemporary reasons for why marriage continues to be so important in Indian society. So the victim is likely already facing a high degree of familial as well as social ostracism for entering into a sexual relationship outside the context of marriage. And this social isolation can then heighten the victim's vulnerability, and she might feel like she has to prove at any cost that the relationship has worked out, right? Because she's already made too many sacrifices to be with the defendant. And given that women are themselves developing their preferences in a social context which prizes marriage over sexual autonomy, it can sometimes be very difficult to disentangle, when the role of context ends and where the role of agency starts. So I find this quote from a lawyer quite interesting because, she starts by saying that this association between sex and marriage is because of illiteracy. But then she also says that she associates sex with marriage, and she's a qualified lawyer, right, highly educated. And then she also assumes that I also associate sex with marriage, even though, of course, at the point at which I met her, I was, a qualified lawyer with multiple law degrees. So she says, so it does seem that she's talking about something which is beyond illiteracy, right? She's not just talking about illiteracy. So speaking about Indian women, she says sex is a very big thing for them. Still now, it's a big thing for me as well. I'm sure for you also. I'm sure nobody can just go and sleep with someone. I need to have sex to satisfy myself. Sex is something synonymous with marriage. And so, despite the several assumptions she's making, I think there is something really important here about marriage being the ticket to respectability. I find that a very evocative example of this for me, it comes from some fieldwork that was done by Sneha Krishnan in a different part of the country. So Krishnan works with young women in Chennai trying to understand their sexual self-expression. And she highlights the distinction that some of her participants make between rape and violent rape. And just assume when I'm talking about the Krishnan study that I'm using the term rape within like scare quotes, yeah. So the unqualified word rape, according to her participants, refers to men's passionate behavior or uncontrollable desire. So Krishnan records girls as saying, "Did your boyfriend rape you or what?" Or, "I just want to go out and get raped, dude," while discussing their dating life. And one 18-year-old woman takes great delight in describing her rape by her boyfriend as the kind of sex that leaves hickeys. So, since there exists no socially acceptable vocabulary for discussing these young women's sexual desires, the word rape comes to stand in for all types of illegitimate sex, including consensual sex outside of marriage. And the denial of sexual agency for these young women, it becomes one way of maintaining their respectability. For many practitioners that I interviewed, it was quite frustrating that we continue to associate sex with marriage in this way. A feminist academic I interviewed, for example, was really quite disappointed that despite of having taken that initial step of exploring sexuality outside the context of marriage, these women ultimately wanted to fall back into the safety net of marriage. Other practitioners were a bit more strongly worded, shall we say. So this is again a criminal lawyer of several years standing and in this quote, he's referring to rituals that are associated with a Hindu wedding. So he expresses his frustration that somehow in some part of the mindset of people, you still have that concept that I am supposed to offer my body to anybody only after I've had vermilion put on my head or a garland around my lousy neck. And then we had a third set of frustrations around these cases, which was basically when people were not so troubled by the invocation of rape laws in these cases, but they were troubled that women didn't stick to their story, right? That they then didn't support the prosecution till the very end. So this is a quote from a victim support person who says, "Well, what I mean to say is the victim should be stable in her statement. Don't get diverted. If he marries me, only then is an acquittal possible. Simply say, I want him to be punished because he has raped me. He was in a relationship with me for 3 years, and after having sex with me, he refused to marry me." So, taken together, these two categories of cases then raise quite sticky questions about victimization and agency. They're examples of how women in India leverage rape laws to secure outcomes, which are incompatible with stated legislative objectives, but which are better aligned with women's own conceptions of justice. And these conceptions of justice, in turn, are heavily linked to the social and material conditions of women. They often involve, from the women's perspective, selecting the least bad option from a very limited menu, making it quite difficult to draw neat boundaries between victimization and agency. So I don't claim that victims never want retribution. And obviously you're smiling now. And I also don't claim that what the victim wants should necessarily be determinative of what the legal system is willing to offer. But if some of the agreements that I've talked about make us feel uncomfortable, then I think that's a strong indication that we need to engage more with the social and institutional pressures on these women. So if we don't want rape victims to trade rape convictions for money or for housing or for employment, then actually that's a strong indication that we need to focus on women's poverty or unemployment or homelessness. If we are uncomfortable about women picking alimony rights or custody rights over the rape conviction, then that's a strong indication that we have not provided women with accessible and satisfactory routes to be able to exit unsafe or abusive marriages. If we don't want women to invoke rape laws in promise to marry cases, then we actively need to work towards a society in which women are free to explore their sexual desires. What suggests about criminal justice? Well, as it stands, not spectacularly much, but I think taking women's experiences of rape trials more seriously can maybe help us work on a roadmap for a better tomorrow. So I'm going to stop there. I look forward to hearing more from you. Thank you for listening.